Good evening, this is John Milburn for Central Queensland University. Tonight we're in week 9 for term 3, 2017. We're dealing with statutory interpretation, and in some ways we are dealing in week 9 with material that you would typically expect to cover in week 1 of a statutory interpretation course. Our text, Michelle Sanson's text, is one that we are following week by week. So Michelle Sanson deals with traditional common law approaches to statutory interpretation and the meaning of words in week 9, and that's when we'll deal with it. Now, for what it's worth, I entirely agree with Ms. Sanson's approach. The reason is that we don't primarily look to the common law now when determining issues to do with statutory interpretation. We look to legislation, and the common law will supplement and explain the legislation. It wasn't always the case prior to the Acts Interpretation Acts and the increase in statutory interpretation principles. We would look to the common law initially. And of course, the entire approach to statutory interpretation has changed. Now that we have the purposive approach to statutory interpretation, we're required to look at the greater context, the purpose, the extrinsic materials, the background, and that almost makes obsolete at least one of the common law approaches, which is the literal approach. But certainly when I went through university, and again we're talking late 70s now, so it was ancient history, two things. The first is there was no unit or course or subject, as we used to call it, called statutory interpretation. It didn't exist. So statutory interpretation is fundamentally important, but it's relatively new in terms of the way in which law is taught. And that's a reflection upon the way in which statutory interpretation has developed as a very important aspect of legal practice generally across the board. The second thing is that when we were taught about statutory interpretation, which was probably an introduction to law, it was probably over a week, and we were taught the literal approach, the mischief approach, and the golden rule. So we were taught those common law approaches, and there was no purposive approach back then. So everything has changed. So Michelle Sanson's approach to the way in which she's written the textbook is this. Why would I start the story by telling you about something that really doesn't apply as the main issue now? If you want to know about something, you want to know the position now, you want to know how things work, what is the correct procedure. And having bedded that down, you might then be interested in what it was and the historical aspects, rather than necessarily the other way around. Anyway, that's the approach that's been adopted. Yes, Deb? Hi, Deb, you've got your microphone on. Do you wish to ask a question? All right, we might just mute Deb's microphone. Okay, so that's why we're dealing with issues of common law now. It's still relevant, but it's not the key part of the curriculum. Before I get into the content, I'm going to ask for a favour of you, and that is feedback. You would have noticed that this week is the commencement of feedback. The big red button, have your say, in the top left-hand corner of Moodle. I do ask that you please take some time to provide feedback. You've got a few weeks to do that, so there's no rush, but don't leave it too late because it just disappears. And if you're having any difficulties in this unit, please let me know. If you're having any difficulties with the assessment or any issues of concern, it's a great opportunity for you to tell us. Also, tell us what you think about the unit. It's important for the university, and it's certainly very important for me. All right, so having said that, and asked for your favour, we'll press on. I have mentioned in the past, both I think in this unit and certainly Introduction to Law, as part of legal research skills, that you should consider some materials that are prepared by the government, or the government branch the executive branch of government. And what I'm referring to particularly is the Queensland Legislation Handbook. Now, I'm sure there are counterparts in other states for those of you who are practicing or studying interstate. But tonight I want to deal with the Queensland Legislation Handbook, and the reason I'm mentioning that is that incorporated within that context of the handbook is material that relates to common law and the common law approaches to statutory interpretation. In other words, that handbook, which is managed by the Office of the Queensland Parliamentary Council, provides the way in which legislation comes into existence, and it also provides for the way in which subordinate legislation comes into existence. So it's used by policy officers and instructing officers. Now, given that the OQPC is responsible primarily for drafting of government bills and most subordinate legislation, when it does so, it must consider common law approaches to statutory interpretation. So what better resource, I think, in many ways, than to look at that legislation handbook to get an idea of how the people that draft legislation deal with issues to do with the common law approaches. Also, you'll see some commentary in relation to issues to do with constitutional matters, and we all know that the Commonwealth Parliament makes laws about particular matters which are referred to in the Constitution. There's a list of matters where there is some common areas, and of course we know that the Commonwealth Parliament makes a law, it overrides any state law on the matter. And the state law is invalid to the extent to which it's inconsistent with the Commonwealth law. Now, does anyone know the section of the Constitution that says that? I asked that and I can't remember, I haven't got a note. I think it's 109, but correct me if I'm wrong. Okay, so coming back to the legislation handbook, let's share the screen. I'll attempt to do that successfully. On the screen now, please let me know if I'm wrong. You should see the Queensland Legislation Handbook. You'll see the reference there. It's through the Premier's Department. It's pretty easy to find. And you'll see that it governs the process of how to draft legislation. Now, the reason that I'm drawing this to your attention is that you'll see some material that will be familiar to you from your reading. So, for example, if you look at 6.5 and 6.6, which is under the heading of subordinate legislation, it specifically deals with some issues that relate to the common law. So 6.5, general presumption that legislation will be prospective, and 6.6, dealing with retrospective operation of beneficial provisions. Now, they're topics that we're really going to be covering next week, because Chapter 10 deals with statutory presumptions, and I want to raise this with you now so that you can read the legislation handbook in the context of dealing with those legislative statutory presumptions, as well as getting an idea of how the traditional common law approaches are dealt with by lawmakers. So just to bring some specific things to your attention, for example, when we're talking about policy development of a government bill, you'll see 2.11, which deals with other matters needing consideration for thorough policy development. If we click on that link, you'll see that there's a good deal of information, and the one that I'm going to bring to your attention is down the bottom, 2.11.16, which deals with the liability of directors or executive officers of a corporation for a corporation's offences. So the proposed legislation in relation to directorships should not make directors or executive officers personally liable for offences committed by a corporation unless there is a clear justification for doing so. So if it's proposed to include legislative provisions imposing liability, and I'll just actually go to this so we can follow it on screen. Okay, so you'll see there, if there's a, if it is intended that there is personal liability on the directors of a company, then it must be very clear there is justification for doing so. And there's a process. The Premier must be consulted, Cabinet's involved, and if the provision is included, it must not reverse the onus of proof. That is, it must not require a director to prove that he or she did not authorise or permit. And it refers to the Directors' Liability Principles published on the Council of Australian Government's material. So the reason I'm raising that with you, and I'll stop the share now for a sec. The reason I'm raising that with you is this, that you will read about these common law approaches, these presumptions in common law, and you'll often find a reference to that in the legislation handbook. Now, if we're talking extrinsic materials and how to use them in an effective manner, then it seems to me that by reference to the handbook, you have a very clear statement of what would be the intent of Parliament. So if you're arguing this is the Parliament's intent, and you go to the handbook and say, this is the guideline by which the people that actually drafted the bill are bound, it would be pretty safe to assume that the intention of the drafting was to make it consistent with the obligations imposed under the handbook. And if that suits your argument, it strengthens your argument for the presumption being in a certain way. And I've just selected that as an example, 2.11.16, dealing with the issues of liability of directors or executive officers. So keep that handy throughout your studies. If I go back to that handbook, a few other things that I want to draw to your attention, and I'll share the screen once again. So, for example, have a look at Part 3, which deals with the drafting process. See if I can get to the top of the page first. I'll do it this way. Sorry. All right, so Part 3 deals with the drafting process. And you'll see there the OQPC is involved in that process. For example, have a look at the role of the drafter, and in particular, say 3.5.2, which talks about acts being of general application. And the reason I'm bringing this to your attention is that it now brings into effect issues to do with Acts Interpretation Act, the Statutory Instruments Act, and the Legislative Standards Act. So they're the three key pieces of legislation that deal with the issue of statutory interpretation generally in Queensland. And you'll see that the drafter, in preparing legislation, must consider those acts of general application, and there's a guideline there about what those acts of general application do and how they're introduced into and dealt with in the material. Another thing that you've seen often, and this is under 3.7 under the heading of other matters, is explanatory notes. And you'll see there why the explanatory notes are important, how they come into existence, what is the role of the Legislative Standards Act 1992 in that regard. Other things that you might be interested in under the heading of the parliamentary process, 4.8 deals with issues to do with the second reading. And under Part 5, generally, we have the issue of royal assent. Then, as I mentioned briefly, we have issues to do with subordinate legislation, which is in Part 6. So if you're looking for a general statement about what subordinate legislation is and how it works, then you can look at that. When you're arguing a case, sometimes you're arguing that, for example, a council is taking action in relation to subordinate legislation, but it may go beyond its powers. It might be what we call ultra vires, the delegation. So it might be an issue of unauthorised subdelegation or delegation to the council. So have a look at 6.4. That could provide you with some handy arguments, that type of reasoning, when you're arguing against, for example, the actions of, if you're arguing against the action, say, of a council officer who's purporting to take action under some subordinate legislation, then go back to the handbook, have a look at 6.4, ask yourself whether, in fact, the authorisation has been properly authorised to the power that's making the decisions and working under those decisions. Other things that you might want to consider in the handbook, and I'm sorry, I'll move as quickly as I can through this so we can get on to other topics. But 7.1, there are some fundamental legislative principles, and these are of general effect. Again, you're dealing with issues that to some substantial degree relate to common law. So if we look at, for example, the rights and liberties of individuals, it provides a statement about a number of common law rights which must be considered by legislation makers in the context of how the common law issues are dealt with when creating statutes. And you'll see there that there are certain rights, for example, that legislation must be consistent with principles of natural justice. There's then the legislation provides appropriate protection against self-incrimination, that's number 6. And I'm just selecting a few. Number 7, legislation must not adversely affect rights and liberties imposed retrospectively. So this list, which is quite extensive, is not completely extensive. And if you want a case, there was a decision of X7 against the Australian Crime Commission, 2013. I'm not sure that it's mentioned here. So it's X7 against the Australian Crime Commission, 2013, HCA 29. In that case, the court recognised that the rule about self-incrimination most frequently applied to legislation that affected rights, but the majority said that the rule also applied to legislation that could have an effect on defining characteristics of the criminal justice system. So it basically said that it's the principle about self-incrimination operates very widely. Sure, perhaps if I go to that principle, it might actually say something there about X7. No, it doesn't. It talks about sorbia and the common law. Okay, so thank you for allowing me to share with you something that I've probably shared with you already in terms of the legislation handbook. So let's talk about, so is everyone hearing me clearly enough, or is it starting to drop out? It might be while I share on the screen. Can you hear me now? All right, that's good. Thank you. I'll try not to share the screen. I think that has an effect on the bandwidth. All right, so how did you go with your reading for this week, chapter 9? All good? We'll take that. Haven't finished yet? Yes, yes. All right. I think this chapter is fairly straightforward. Some of the key questions that you need to ask yourself as you're reading or as you're revising this chapter are, how does the common law and how do common law and statutes relate to one another? I think that's a really key question that you need to ask yourself. And by referring to the legislation handbook or the legislation handbook, what I've attempted to do is give you a clear idea of how the common law and statutes relate to each other. And the next one is this. As you're reading the material, ask yourself, do we in fact have a coherent body of law that is a fusion of common law and statute? I mean, arguably it's not. It's arguably a work in progress. But I think we've come a long way collectively. I think it's fair to say, as a general proposition, that the common law approaches to statutory interpretation continue to have some use, but they're not absolute use. So common law approaches are something that you might keep up your sleeve, as it were, but not necessarily be your opening line, if I can use that terminology. So we know that the doctrine of parliamentary sovereignty means that statutes prevail over common law, except on High Court decisions relating to constitutional validity. So that's a general principle. How does that all work in the context of statutory interpretation. So in your text, there's a reference to the decision of Brennan against Comcare. It's a 1994 Federal Court of Australia decision. And Gummo J made the following comment. Now, this is in the context of trying to explain how we consider statutory interpretation against doctrine of precedent. Gummo said this: applying the rules of statutory interpretation is different from applying the doctrine of precedent. It would only apply in dealing with the same act where it is directly aligned, factually, and that's unlikely. So statutory interpretation is used in a different manner to the way in which it is in precedent. That's on page 200 of your textbook. So I guess what we're really saying is that be careful about necessarily saying that because something was interpreted in a case in a certain manner one way, it must always apply for the interpretation of that same word or phrase or sentence or section in another case. Gummo would say that only applies if the facts are directly aligned. In Yeager against the Crown, Mason J confirmed that the construction of statutes is a question of law. It's not a question of fact, it's a question of law. Therefore, when it comes to statutory interpretation arising in the context of a jury trial, it's up to the judge to decide what is the interpretation that should be given to a particular word. So that's again in your textbook. Well, what I'm going to ask you to do is carefully consider figure 9.1 on page 202 of your textbook. Now, did you have a look at that? Have you got your text there? Have a look at it. It's at the top. Can anyone tell me generally how to use that table? What does it mean?
Is it showing situations where, depending on, for example, I can see steps there, for example, in Queensland contract law, a lot of it's argued via common law rather than based on strict legislation. And so that there's steps there in various scenarios where that might apply. So you're not starting off strictly from a legislative point of view, you're starting off with the common law view and then moving through to the case law to support your argument.
That's certainly.
Sorry, I can't hear you.
No. Sorry, David. I forgot to unmute quickly enough. But yeah, no, that's certainly a good approach. Did anyone else pick up anything about that table when you're reading it? How to apply it? So Sharon says it's like a brick wall, common law building on top of each other. Then a statute is enacted. Yep. Mary says when the common law view is applicable. Any other thoughts? Thank you, David, Sharon, Mary, for those thoughts. All right, what if we say this, that the bottom of the table essentially represents the historical situation as it was under the common law, generally speaking. For example, where an area of law developed over time in common law, but there's now a statute on that topic, the statute builds upon the common law through codifying it or extending its operation in some way, or it might just replace the common law. So you can see that we've got the common law, then above that, we've got the statutory provisions. So what this has a consequence for statutory interpretation because it affects the degree to which the prior common law may be useful in interpreting the legislation. And it is on page 202. Yep. So have a look at that. And what you'll see is, when you look at that table, that the common law has a place to play in all the scenarios except the second. You'll see it's crossed out, where the statute purports to cover the field and actually replace the common law. So if the statute says this is the only way to do it, forget the common law, then forget the common law. Otherwise, the common law will have some part to play in those scenarios. Legal reasoning is considered in scenarios D and E and F, which you'll find on pages 204, 205 and 206 respectively. Scenarios A, B and C are on 202, 203. So let's have a look at scenario D for a moment. Now this is on page 204 and we're dealing with the way in which the common law is developed through reasoning by analogy to statutory principle. So do you remember in Introduction to Law, we talked about reasoning by analogy? So here in scenario D, we're talking about how analogy is used in statutory principles. And the case that's highlighted there is R against L from 1991. So in that case, in defence to a charge of rape, a husband said it's common law obligation for a wife to have sexual intercourse. He referred to section 114.2 of the Family Law Act, which provided that a court may make an order relieving a party to a marriage from some obligation to perform marital services or render conjugal rights. I mean, it's an argument that is abhorrent. However, it's got some merit in that what he was saying is, why would there be a provision in the Family Law Act to say that a court may make an order relieving a party from an obligation to render conjugal rights if it was not at law an obligation to do so? Does that make sense? Anyway, so he said, therefore it's inherent in Commonwealth legislation that a spouse has an obligation to perform marital duties, and pursuant to section 109, the Commonwealth provision shall prevail against the inconsistency. So it was 109 that we were talking about before. So the court had to really work its way around that argument. It was quite an inventive argument and come to a conclusion that was correct. But wow, you know, why was the legislation included in the way in which it was in section 114.2 of the Family Law Act? To me, that is so strained. It's just crazy. Anyway, did anyone else have any... No, apologies. Sorry. Did anyone else have any problems with that case and the argument? I thought it was an inventive argument. Okay, so Mary says it's no longer current community expectations, that other acts are now involved, such as the Crime Act. Okay. Anyway, it's just the way in which statutory interpretation arguments can be used in a whole range of ways. Now, as the author mentions on page 205, there is an ongoing challenge with the analogy's use of statutes in the development of common law, in that while there is said to be a single common law for Australia, there are 9 separate legislatures, each with power to enact statutes that may differ markedly, and then goes on to give the example of SO and FCT. Have a look also at the example which is referred to in the text of Baker against the Crown, 2012, HCA 27. All the High Court judges refused to use the Uniform Evidence Act to adapt the common law of evidence in circumstances where Queensland, South Australia and West Australia had not adopted the Evidence Act. So that's an example of where each of the individual states, through their parliament, can create differing circumstances. Right, so scenario D deals with an example of where legislation had to be worked around to come to the right decision. Then we have page 216, if I could bounce forward to that. You would have read, actually, while we're doing that, can anyone tell me what are the 3 traditional statutory interpretation approaches of common law? This is normally the first thing that's said in statutory interpretation class, but we're doing it right at the end. What are the 3 common law approaches? I'm sure we all know. the golden, right, Melissa says the literal rule, the mischief rule, and the golden rule. Mary says the golden rule. Sharon says mischief, literal, golden. Gary says mischief. Yep. So it is the literal rule, the golden rule, and the mischief rule. What's the literal rule all about? Taking the actual meaning. I think it's probably fair to say you look at the Act and it says X. I'm therefore going to construe this as X, and so if the facts indicate X, I don't need to go beyond that. So don't tell me what Parliament intended. Don't give me explanatory notes or second reading speeches. I don't want to know about them. I'm just going to apply the law as it says.
I think I heard a quote by Gleeson saying it's a mechanical approach.
Yes, a mechanical approach. Yeah, it's very, very, very straight down the line. I mean, if you're looking at the mischief rule, then sure, you'll start to think about the context, and you'll start to think about the reasons why the Act came into being. So what's the golden rule? Usually we put the golden rule in between the literal rule and the mischief rule. What's the golden rule? I'm not dwelling on this because it's really not our law. Prevent errors, yep, says Michael. Only used if there's an absurdity by reading literally, says Tanya, and I agree with that, so that's fine. All right, have a look at page 220 and problem 17. I think this is a really good exercise. If you've read it and been through it and considered it, very good. If not, please do so. Cocaine, it goes straight to your brain, is the heading. So this is based on Gideon against the Commission of New South Wales Crime Commission, 2008, HCA 43. So what happened in this case? An informer, excuse me just one sec. My apologies, too much talking. Right, so an informer sold Gideon 2.5 kilos of cocaine. Enforcement officers believe the cocaine would be recovered. That is, it would then be on-sold to end users in 70,000 or 100,000 packets. The legality of an operation is under statute in circumstances where the Commissioner may grant an authority for a controlled operation, but only if engaging in conduct, unless engaging in conduct that is likely to seriously endanger the health or safety of others, or result in serious damage or property. And the High Court decided that any other person literally means what it says, which means that the provision did cover end users. Therefore, it had no lawful power to conduct the sting operation. Okay, yeah, sorry. Michael saying the microphone doesn't work, so sorry about my voice going. I'm pretty close to wrapping it up for this evening. Does anyone have any questions? I'm not finished yet, but are there any questions about what we've discussed so far? If you've got questions about the exam, we might deal with those at the end. Okay. So I'm going to ask you this, just as a little refresher on what we've said tonight. This will be a yes or no, or perhaps maybe. I mean, is applying statutory interpretation rules similar to applying the doctrine of precedent? What do you think? Now think about what Gummo said.
No.
Yep, I agree with that, David. No. Michael says no. Oh, lots of vote. And not really, and no. Yep, I agree with that. So the point that I'm trying to make there is just be very careful about treating statutory interpretation cases in the same way that you would for general precedent cases. But if the facts are sufficiently similar, then I think it's fair to say that the interpretation of a provision by a superior court is binding on the courts below it. So I'm having it a bit each way, but I'm saying it would be a very brave magistrate, for example, who adopts a different meaning to words which have been considered by the Court of Appeal. So if you've got a lower court and you're dealing with facts that are substantially similar, then the interpretation given by the higher court should be followed by that lower court. All right. Another quiz question, and this time it'll be an A, B, C, D issue, so I'll get you to cast your vote. So you ready on the buzzers? Under which traditional common law approach would resort to extrinsic materials be least likely? A, the literal rule, B, the golden rule, C, the mischief rule, D, extrinsic materials were not used by any of them. All right, we're getting a lot of votes. Oh, everyone has got it right. A, the literal rule. Yes. So under the literal rule, why would they bother going to extrinsic materials? Because it means clearly what it says. All right. Now, if you're arguing an appeal because a magistrate or a district court judge, for example, has interpreted a word a certain way, and you say that the court interpreted incorrectly, is that a valid argument to appeal the decision? Yes or no? Come in with your buzzers. Yes, it can be. Yes, yes, yes. Good. All right, it can be. So if you don't like the way in which a court interpreted something, you can appeal that on the basis that it was an error of law. Now, where was it tonight that we talked about the process of interpreting statutes as being a function of law rather than a function of fact? Do you remember the case? This is testing you. It's testing your memory. Wasn't it Jaeger? Was it Jaeger where they said that? Jaeger says Melissa. Yeah. Okay. All right. So next question for you is this. And I'll A, B, C, D again. So if we're ready to go. Prior common law can be useful in statutory interpretation. A, always, common law is superior to statutes. B, if the statute provides for this to occur. C, unless the statute completely overrode the common law. Or D, if the statute is ambiguous or leads to a result that is manifestly absurd or unreasonable. We're getting a mixture of votes. We're getting a few C's and a lot of D's. All right, well, I think the answer is C. So let's analyse that. So what I'm saying is that prior common law is useful in statutory interpretation with one exception, and that exception is unless the statute completely override the common law. Now, the reason I say that is if we go back to our graph on page 202, you'll recall that we said that common law is useful in statutory interpretation in all but one circumstance. You can see where it's crossed out in column B, and that is where the statute replaces the common law. Don't look at the common law, don't argue the common law, because the statute completely overrode it. So if you're answering an exam question and the examiner makes it clear that the statutory interpretation, that the statute now completely overrides the common law, I'd suggest the last thing you want to do is argue the common law. Does that make sense? All right. Now, we did have a lot of votes for D. And a lot of people said If a statute is ambiguous or leads to a result that is manifestly absurd or unreasonable, then we can look to the prior common law. Yeah, it's probably right. It's probably right. But it wasn't maybe the best answer, or the answer I selected. So I'm happy to award some marks for those that voted D on that occasion. All right. And just because tonight we're talking about common law approaches, we'll finalise with one last question, which is based on the old common law. So which of the common law rules, and we know what the rules are, there's 3 of them, which of those 3 rules apply most likely where a court decides in interpreting this? In the event of a vessel sinking, all passengers are entitled to compensation. If a court says no, but that it doesn't mean stowaways and pirates. Is the court applying the literal rule, the golden rule, the mischief rule, or all of them? A, B, C, or D? A literal, B golden, C mischief, D all of them. Which one do you think? We're getting some votes. I think it's one of 2. It's clearly not the literal rule. No, we're getting some votes for all of them. D. And I'm dropping out on some people. All right, we had a mixture of votes. I would say the mischief rule. I would say that the court is likely to be making a ruling such as that based on what was intended by Parliament. It's always a tough argument. You know, when you've got clearly stated legislation and a court makes a ruling based on what was intended, it's always tough. I say tough from the perspective of an advisor, because picture yourself in a situation where a client comes to you and says, I am a stowaway, but I want to obtain compensation. And it says that all passengers are entitled to compensation. You know, it's a brave lawyer that says, no, you can't apply for compensation because that's not what they intended, even though that's not necessarily what they said. Do you understand what I'm getting at there? It's always a difficult argument. Okay, are there any questions about what we've covered tonight, your reading or the second assessment or the examination? All good? And Gary, who has a nautical background, says that stowaways, once discovered, are the captain's responsibility. Thank you, Gary.
John, you did mention at one stage that you were going to get us, we would be notified of our particular log-on time because you didn't want everyone to be logged in together. Is that what you're arranging tomorrow in this meeting? And we will be personally notified of that? Yes.
So my intention tomorrow is to clarify a few things. I'll be saying that I want everyone to have full access to materials, paper and online materials. I do want people to be able to use voice recognition to type their material if that's the way they do it. I say that because that's the way I do it, and I know Gary uses that approach. Maybe others do as well. And I do want to have clear statements about when people start and when they log on. So yes, that's part of it, Mary. That's part of what we'll be discussing. So I think there's a range of times, but I just haven't worked out the logistics. You know, have I given you the range of times that I think from memory, have I just said a certain time?
Yeah, you've just set the certain time, but then in one of the later shoots, you said that you were going to try and arrange for us to individually log on at different times for us.
Yeah, and I think part of that is actually, or did I say between 2 and 6 p.m? All right. Yeah, in Queensland, 4 to 8. That's it. Yeah. So the Proctor U service has a limitation, and that is that in an ideal situation, I'd like it to be like an invigilated exam where, say, in Queensland time, and I'll always talk Queensland time, in Queensland time, everyone starts at 5 p.m. and everyone finishes at, say, 7 p.m. That's what I'd really like. However, I don't think that can be done with the invigilated service. So I think that they want a range of times to suit them, and that might suit us as well. So invigilated examination is where you actually attend a centre physically. You know, you go to Brisbane, and you sit at this address and you have someone watch you. I used to have a lot of my exams at the old Cloudland, if you remember that, in Brisbane back in the 70s and 80s. No, you won't remember, Tanya, you're too young for that. So it means going to an actual centre. So this is an attempt to have something that's like an invigilated examination, but it is over the internet. So it will be staggered to some degree. So it looks as though I've said between 4 p.m. and 8 p.m. in Queensland on the night of the evening of the exam. So what you could start to do is think about what would suit you the best, and we'll try and work out some way of locking people into their exact time.
Can I ask a quick question?
Yes, David.
About the exam. I may have missed someone already asking this question, but you did say that it's going to be open book and we'll have access to pens and paper, and if you use voice recognition. I worked with someone who said that she had to do a university exam like something that wasn't Proctor U, where the actual program shut down her computer so she couldn't access anything else on her computer. That's not the case with this, is it?
No.
We can use the internet for quick reference, or, you know, okay.
I absolutely want all of that. So that's what I've said to them. And I'm getting indications that that'll all be fine, but I'll try and bed that down further tomorrow. So in other words, it's full open book. That's my intention. I want it to be open book.
And John, where will we find the login start? Will that be actually where it's listed as normal, or just click that on and that's where it will tell us to go?
Yeah, I think the process should be that you are given clear detail about the time to log on and how to log on. It should just be, like joining a Zoom session. You click a button and you're there. And then you go through a little process where they will check your ID, so you have to show your student ID on screen, and they'll want you to remain on screen. You can't get up and walk around, because even though it's open book, you can't go and talk to somebody else and say, tell me the answer to this. You've got to be at the screen for that whole time. I don't know about toilet breaks, so let's hope that doesn't happen. I don't know about internet dropping out on the day if we have big storms. Cyclone season, that could happen. So we don't want it to happen. Yeah. Sorry, Mary.
I was just saying, you told me when I asked that question about loss of internet, because since New Year's Eve I've had terrible loss of internet, and Telstra were out here yesterday and they told me that they've identified the problem, but they have no time of when they can repair it, and every time we get a storm I'm going to lose it. So I'm actually heading interstate to relatives who have a fairly protected internet source.
Yep, and that's exactly
than a local McDonald's.
Yep, and that's exactly the advice that I've given Mary. If you've got doubts, then get to a secure site. Now, having said that, we had a situation with an invigilated examination in one of my subjects, where in Sydney they're physically undertaking the exam, and the fire alarm went, and the fire said, you've got to get out now. So, it can happen even if you have a face-to-face situation as well. So, no, Michael was saying, do we go to a centre? No, but you need to be in a secure spot. And so, Mary, I really apologise because of your limitations with your dodgy internet. I'm forcing you, in a sense, to go somewhere else, where others may say, I've got a good internet, it's secure, so I don't have to move. So I'm sorry about that.
It's been such a problem even getting this, the actual onto the internet over the past since New Year's Eve, to even get this assignment that's due tomorrow for Intro to Law, to actually get it enough time to get on to the internet. and I was within 1 hour of the deadline because I had no internet all day last Thursday to just upload that statutory interpretation. You know, and I actually had to go to a 200-kilometre round trip to a friend's to do it on a memory stick.
Oh, okay. Yeah. That's
I mean, it's
tough.
just impossible. It's just shocking. But and cyclone season normally starts about now, but we've had terrible cyclone kind of storms, electrical storms since New Year's Eve where I live.
Yep.
So it's come early.
I understand. So thanks for your consideration.
And can I just ask some advice? Because
Sure.
Telstra are still charging me the set rate despite no service. So, you know, what can I do there? Contract law?
Telecommunications Ombudsman.
Tried that.
Yeah. I get a lot of people that say
The problem is you've got to speak with Indians overseas and they just have no idea.
I know, it's tough. I know. No, I can't go there, Mary, sorry. All right. Any other questions?
I was only joking.
Yeah. No, I understand. Thank you. Any other questions, comments? All good? Thank you very much for participating, and really appreciate everyone doing so consistently each week. So we'll see you next week. I'll provide you with an update when I can in relation to Prop to You. Otherwise, if you have any questions, as always, please ask through UCrew. If you have any material, as you've been doing, please share that through UCrew. Been a really good cohort, so thank you. All right, all the best, and we'll see you next week. Bye then.